Welcome, everyone. Thank you all for taking your time to join us today in this event. I hope you are all safe and healthy in your homes and in your offices. My name is Karina Daya, and I'm the moderator of this webinar. I am a biologist. I have a master's degree in biochemistry, and I'm a partner at Venturini IP. I'd like to start saying that we are very glad with this today's section. We had a lot of subscriptions, and we expect attendees from all over the world watching us from different countries, different continents, and with the most different backgrounds. So today we will count on the expert opinions of our four speakers to help us answer the question that is the title of today's webinar. How can pharmaceutical companies and universities benefit from the new Brazilian IP system? These experts will share with us their insights on the Brazilian pharmaceutical market, on the patent landscape, on tech transfer landscape, and on the new Brazilian IP system. This event is co-hosted by Louis Lozue and André Sarmento. Louis is my colleague and my partner at Venturini IP, and his work seeks to support the Brazilian industry, Brazilian universities, research centers to navigate the entire cycle of technological innovation. He is a lawyer, admitted to both the Brazilian and French bars, with over 10 years of experience in IP, especially with patent litigation. André is an IP consultant responsible for the corporate development in Europe, Asia, and Brazil in Chip Global IP. André manages and helps in the management of intellectual property portfolios of law firms, companies, R&D institutes, and universities. He is an industrial property agent in Portugal, in European Union. We are also very pleased to welcome the vast experience of our two guest speakers, Professor Rui Seabra Ferreira Jr. and Camila Raposo de Oliveira. Professor Rui is an associate researcher at the Center for the Study of Venoms and Venomous Animals at São Paulo State University, and associate professor at the Medicine School of Botucatu. He holds a degree in veterinary medicine and master's and doctor's degree in tropical diseases from São Paulo State University. He is a PhD in immunochemistry at Butantan Institute. Professor Rui is a member of the board and is the president of the Brazilian Association of Scientific Editors, member of the board of the Technological Park of Botucatu, and member of the Brazilian Pharmaceutical Sciences Academy. Camila is a patent consultant at Biolab Sanus Pharmaceutica, and she is a teacher at Oswaldo Cruz University and Racine Institute. She is a biochemical pharmacist with a master's degree in immunology from the Institute of Biomedical Sciences at São Paulo University. With more than 18 years of experience in IP, Camila has extensive knowledge in the strategic use of patents in the process of developing new products and partnerships, and in monitoring the risks involved with patents. From the ones who just joined us, welcome. I'm Karina, and I'm the moderator of this webinar. So to finish this introduction, I would like to give you some final informations. Our guests, Camila and Professor Rui, we will speak in Portuguese. But for you that don't speak Portuguese, don't worry. We will have the simultaneous translation into English throughout this webinar. At any time, you may switch the language and activate the audio of our interpreter. To run a quick language test and to verify if everything is okay with the translation, I would like to greet our Portuguese and Brazilian participants in Portuguese. Bem-vindos, bem-vindas. Espero que todos estejam bem de saúde. Todos nós, todos os apresentadores de hoje, temos o português como a nossa língua nativa. Mas como boa parte da audiência desse nosso webinar não tem o domínio do português, nós vamos conduzir o evento em inglês. Apenas a Camila e o professor Rui falarão em inglês. Eu gostaria também de agradecer a presença de todos e desejar um excelente evento. Is everything okay? Okay. So this webinar will last around 1 hour with a Q&A section afterwards. If you have any question, please submit it to us by clicking in the chat button below your screen at any time during the presentations. I will get all the questions and our speakers will answer them at the Q&A section right after the webinar. Now I'm going to hand over to André Sarmento to start the presentations. Hope you all enjoy this event.
Thank you very much, Karina, and hi all. My name is André Sarmento. I work in CHIP Global IP. I would like to, before start this presentation, I would like to thank not only Karina, but also the other co-hosts, Louis, Professor Rui, Camila, for your presence. I would like to thank all the attendees for being here also. We have people, as Karina said, from a lot of different countries, from a lot of different continents, and with different backgrounds. I would say especially in the pharmaceutical area and people that work in universities, but we have a lot of very different and interesting people here. So I'm happy to be here with you today. Our webinar, I will be responsible for giving you an initial context to the pharmaceutical market in Brazil. And then after me, Louis, Professor Rui, and Camila will give you information about the patent and the tech transfer landscape. So I would like to start here with giving you this context by telling you that, as you know, Brazil is a very relevant country. It's the fifth biggest in the world. It's the sixth most populous. We're talking about the ninth GDP in the world. But not only Brazil is that economically or politically relevant, but also it's very relevant as a pharmaceutical market. So one of the things that we wanted with this webinar was to tell you that Brazil is a market to consider when we're talking about this area. Nowadays, Brazil is the seventh biggest pharmaceutical market and is expected to rise to the fifth position by 2023. We're talking in about a 2-year period of time. Which is very, very interesting, and it shows the importance of the Brazilian market. The Brazilian pharmaceutical market is expected to move between 39 billion to 43 billion in that same year of 2023. I think it's interesting also to state that the greatest growth when we're comparing 2018 and 2017, which are the years that we are looking at, the greatest growth was seen in new medications and their patent, which increased by almost 20% to reach 8.2 billion reals. And even we even have some data about the Brazilian Ministry of Health that in the year of 2018 purchased a record of 16.98, almost 17 billion reals in medications. We're talking about an increase when compared to 2017 of more than 41%. To conclude this very initial approach, I'd just like to say also that in the following year, 2019, the Ministry of Health spent 5.3 billion on immunobiologicals, which represents almost 30% of the total spent annually by the Ministry of Health on medicines. Here you can look at two graphs that are related also with the Brazilian pharmaceutical market, but in different ways. On the left, you can see the statistics of the type of medication in Brazil. This data is from the year of 2015 to the year of 2017. And on the right, you can see the main players of the pharmaceutical area in Brazil. So the two or three things that we can conclude looking at the graph on the left is that the new medicines are the greatest share in the pharmaceutical market, in the Brazilian pharmaceutical market, while the biologicals are the ones that grew the most if we talk about this specific period of time. On the right, we have a different approach. We can see the 10 biggest players of the Brazilian pharmaceutical market, as I told you. And one interesting thing to notice is that 6 out of the 10 are Brazilian. So you can see that the first position is to a Brazilian pharmaceutical company, Ache. You can see several others like Pharma and others. And it's interesting that you have Neoquímica and Mantecorp that even belong to the same group, to Group Hypera Marcas before. So together they would even have a more relevant position if we consider both. And it's very interesting and very active. The fact it shows a lot of activity in the Brazilian market that the Brazilian companies have so much importance here. I would like to salute you all that are attending this webinar, because I know that more than half of these companies have people attending our webinar, and I would like to thank you all for that. Here we have some more data that might interest all the pharmaceuticals, universities, and people that are here with us today. On the left, we can see the number of the volume of patent applications in the 20 largest offices. It's not that surprising that China and the US are in the two first positions. What is interesting is that one of the interesting things here is that China has more patent applications than all the other 19 countries here represented combined. So we're talking about a huge volume of patent applications. We're talking about China having more than the double of the US and 9 times the volume of EPO, the European Patent Office. Brazil is in a very interesting position as it's the 11th jurisdiction here. Of course, that we predict, our colleagues and us, we predict that Brazil will clearly be in a better position in the following years, not only due to its potential, but also due to the measures that especially Louis is going to talk about in some slides, the measures that the BRPTO is taking for these numbers to get better and to develop. Two things that we conclude also from this graph on the left. The protection of the patents is much more intense in the markets with the well-developed technology-based industries, and clearly in the large consumer markets. On the right, you can see the percentage of participation of non-residents and non-residents in patent applications. Brazil, the country that interests us today, that interests us all today, has clearly more dominance of non-resident patent applicants. We're talking of a percentage around 80%, which we don't think it will change that much in the future. I would like also now to show you some data that is related to 3 different areas, medtech, biotech, and pharma products. So if on the left we have the volume of patent applications that were filed, on the right we have the ones that were granted. We can see that the 3 areas on the left didn't have that much of didn't change that much their line, with exception of medtech during a 5-year period where there was a spike. However, in 2018, the year of our analysis, they were the medtech and the pharma products were at the same level. Another interesting thing to conclude is that the biotech never surpassed since from 2008 to 2018, never surpassed the other two areas. On the other hand, when we talk about the number of granted patents, we can see that the medtech patents have greater numbers, have a greater growth, but all of them show huge growth. But the medtech one clearly has seen a growth that is much more significant than the other two. Louis, over to you. I think you're on mute, Louis.
André, thank you very much for this overview of the Brazilian pharmaceutical market. My name is Louis. I'm partner at Venturini IP. So first of all, good morning or good afternoon to all attendees, depending on where you are located. It's a pleasure for me to be here talking today about some specific aspects of the Brazilian IP system. So moving on to the second part of this presentation, we opted here to present the patent and tech transfer, technology transfer landscape. And before talking about this technology transfer landscape, we would like to first talk about what is the patent subject matter accepted in Brazil, and what type of claim formats are accepted in Brazil. The objective is really to give you practical advice or approach to what is acceptable by the BRPTO, the Brazilian PTO, when filing patent applications related to pharmaceutical or biotech technologies here in Brazil. On the next slide, please. So patent protection available in Brazil, according to our patent statute, we have patents for both products and process. Utility models and certificates of addition are also possible, are also available. What would be not non-patentable according to a Brazilian patent statute? Anything contrary to morals, property, public security, order and health, substances, matter, mixtures, elements or products of any kind, also the modification of their physical chemical properties and the respective process of obtaining or modifying them. Living beings in whole or in part, they are not patentable, except for transgenic microorganisms that meet the patentability requirements and that are not considered discoveries. Another important aspect of our patent statute, it's related to claim amendments here in Brazil. So the Brazilian PTO conducts technical examination before granting the patent application. So it will look at the novelty, inventive step, and the industrial applicability for an invention requirements, of course, but it will also look at if the description is clear and sufficient enough so as to enable a person skilled in the art to carry out with the invention. It will also look at the specification and if claims are supported by the specification. So this being said, it's important to have in mind that before requesting the substantive examination in Brazil, any amendment on the specification, abstract, drawings, or claims is acceptable if limited to the subject matter disclosed previously. And voluntary amendments to the claims or amendments resulting from technical examination, of course, after the request for examination has been done, they are not acceptable if they imply on broadening the scope of the claims. So it's important to have these aspects in mind when filing in Brazil, and especially before requesting the substantive examination by the Brazilian PTO. Now I would like to hand over to Camila Raposo from Biolab Pharmaceutical. She will give you some more practical tips and insights on claiming formats based on her experience. Camila, please.
Ok. Bom dia, boa tarde a todos. Eu gostaria de agradecer o André e o Luí pelo convite para participar desse webinar e dizer que é um enorme prazer poder dividir conhecimento com todos vocês. Dando continuidade na apresentação, né, em relação ao panorama de patentes no Brasil, tenho a comentar que além da lei da propriedade industrial, o INPI possui diretrizes de exames, né, que são utilizadas pelos examinadores e que também servem para orientar o inventor na hora da redação de um pedido de patente. Além das diretrizes gerais, o INPI possui uma diretriz referente às particularidades da área química, que é definida como a Resolução 208 de 2017, e outra relacionada à área de biotecnologia, que é a Resolução 118 de 2020. Todas essas diretrizes, elas estão disponíveis no site do INPI. Nos próximos slides, eu irei abordar alguns aspectos de proteções requeridos na área químico-farmacêutica e suas aceitações pelo INPI no Brasil. No caso das... Por favor, volta. As reivindicações do tipo fórmula Marcouche, elas são aceitas no Brasil. Porém, para quem não conhece, né, a reivindicação de fórmula Marcouche, normalmente ela busca proteção para várias moléculas que são representadas por um grupamento específico, né, e alguns substituintes variáveis, conforme ilustrado aqui na figura. Para avaliar sua reprodutividade, o examinador deve assegurar que os processos de obtenção de descritos permitam a preparação de todos os compostos reivindicados. Caso contrário, o escopo deverá ser restringido somente aos compostos realmente concretizados, ou seja, produzidos. Sequências biológicas também podem ser reivindicadas na forma de fórmula Marcouche, e a análise dessas reivindicações segue os mesmos parâmetros estabelecidos para os compostos químicos. Fórmulas polimórficas. As reivindicações de fórmulas polimórficas também são aceitas no Brasil. De acordo com as diretrizes, as fórmulas polimórficas devem ser caracterizadas através de técnicas de caracterização físico-química de sólidos. A técnica de difração de raio-x de cristal único, ela é considerada suficiente para uma perfeita caracterização do polimorfo. Na ausência dessa técnica, o polimorfo ele pode ser caracterizado utilizando um conjunto de técnicas, utilizando, por exemplo, a difração em raio-x pelo método de pó, associado a outros métodos de identificação. Sempre importante ressaltar que esses conjuntos de dados gerados, eles têm que ser suficientes para uma identificação inequívoca da forma polimórfica pretendida. Próximo, por favor. Quando a gente fala de métodos terapêuticos ou métodos diagnósticos, né, de acordo com a nossa lei, como já informado pelo Luís, essas tipos de reivindicações não são aceitas no Brasil. Né? Por exemplo, reivindicações do tipo método de tratamento de uma doença Y, caracterizado pela administração de um composto X a um sujeito, não será patenteável. O composto X, caracterizado por ser usado no tratamento de uma doença, também não é aceito. Composições farmacêuticas. Reivindicações de composições farmacêuticas são aceitas pelo INPI. Toda a composição ela deve ser definida pelos seus componentes. Por exemplo, uma composição farmacêutica caracterizada por compreender um composto A e os recipientes B e C. Tais reivindicações também podem englobar características de forma física, por exemplo, ela pode ser sólida ou líquida, uma forma farmacêutica, por exemplo, um comprimido de desintegração oral, uma suspensão ou um comprimido revestido, ou a sua forma de administração, administração tópica, oral ou injetável. E é sempre bom, para facilitar o entendimento do examinador, que se realce qual é o efeito técnico resolvido, né, o problema técnico resolvido com a invenção descrita. Por exemplo, a associação de um ativo com um recipiente específico para resolver um problema técnico, por exemplo, estabilidade ou solubilidade de um fármaco, mistura de recipientes para uma determinada função nas formulações. Embalagens e dispositivos de aplicação também são aceitos no Brasil, né? Desde que as embalagens primárias, muitas vezes são utilizadas reivindicações para embalagens primárias ou para dispositivos de aplicação com dosadores, né? Desde que esses objetos atendam os requisitos de patenteabilidade. Próximo, por favor. Falando de segundo uso médico, o segundo uso médico normalmente se refere ao uso de um medicamento, de um composto já conhecido, para o tratamento de uma outra doença. A atividade inventiva de patente de segundo uso médico no Brasil é bem discutida. Mas, de acordo com as diretrizes, para que o segundo uso médico apresente atividade inventiva, é necessário que o mecanismo de ação seja diferente do mecanismo de ação do primeiro uso médico já revelado. O novo uso deve ser para o tratamento de uma doença de etiologia diferente das descritas já no estado da técnica. E o novo uso não pode ser relacionado a efeitos colaterais já conhecidos. Reivindicações de segundo uso médico devem estar no formato conhecido como fórmula suíça, que seria o uso de um composto X, caracterizado por ser na fabricação de um medicamento para o tratamento da doença. Essas reivindicações de fórmula suíça, elas podem ser utilizadas como opção para descrever alguns tipos de métodos de tratamento. Muitos pedidos de patentes americanos, né, de métodos de tratamento, quando são depositados no Brasil, eles são realizadas emendas voluntárias no quadro reivindicatório para adequar esse pedido na lei brasileira. E, nesse caso, as reivindicações de métodos, quando possíveis, são transformadas em reivindicações no formato de fórmula suíça. Com relação ao material biológico, né, de acordo com a nossa lei, toda a parte de ser vivos, materiais biológicos encontrados na natureza, ou que ainda delas isolados, não são passíveis de proteção por patentes. Produtos também produzidos sinteticamente, mas que são idênticos aos produtos encontrados na natureza, que a gente não consiga distingui-los, eles também não serão aceitos. Nestes casos específicos, poderia-se tentar uma proteção para o processo de síntese, mas não para o produto. Anticorpos. Os anticorpos, para ser patenteáveis, eles devem apresentar características obtidas através da intervenção humana e podem ser definidos por uma sequência de identificação ou por um depósito de material biológico. Já as sequências biológicas, para serem patenteáveis, também não podem ser encontradas na natureza, né? E para definir claramente o objeto reivindicado, as reivindicações devem fazer referência, né, à sequência biológica de interesse por meio de uma sequência de identificação correspondente, ou seja, um DNA ou um RNA, ele deve ser definido por sua sequência de nucleotídeos, enquanto que uma proteína deve ser definida pelas suas sequências de aminoácidos. Um exemplo, por exemplo, uma sequência biológica definida por uma porcentagem de identidade, né, normalmente ela não é aceita por falta de clareza. Isso aqui eu fiz apenas um geral de alguns pontos importantes mais utilizados dentro da área farmacêutica, né? E agora eu devolvo a palavra ao Luiz, que continuará sua apresentação sobre o panorama de patentes e transferências de tecnologia.
Thank you, Camila, for your presentation. Now, moving on, I would like here to mention another specific aspect of our Brazilian IP system, which is the prior approval for patents, for pharmaceutical patents, by Anvisa. So Anvisa is I would say, our Food and Drug Agency. And before 2017, we had a contradictory situation in Brazil, where two governmental agencies would analyze patentability requirements. So we had, on one side, the Brazilian PTO conducting its normal work and examination, who would, for example, grant a patent application and then submit this pharmaceutical application to Anvisa's prior approval. And Anvisa would necessarily automatically conduct its own patentability analysis. And so this, as I said, this was a contradictory situation, because Anvisa sometimes would say that the patent application that was granted by the Brazilian PTO did not comply with the patentability requirements and therefore would deny prior approval. So it was a very confusing time. Many lawsuits were filed to try to invalidate Anvisa's administrative act. So in 2017, an agreement was reached between Anvisa and the Brazilian PTO. And in 2020, last year, 4 guidelines were published by Anvisa in order to clarify its procedures to analyze approval of pharma patent applications. So now the rule and Anvisa's role is clarified. Anvisa can only deny prior approval based on public health matters. Of course, there are exceptions to this rule. And so the main ones, I put it here on the slide. If the application relates to therapeutic matters of interest to Brazilian health policies, Anvisa can perform this patentability analysis. And in this case, this analysis will only be considered by the Brazilian PTO as a third-party observation. The Brazilian PTO is not bound by this opinion of Anvisa. And if the application is related to neglected diseases, Alzheimer's, Parkinson's, rheumatoid arthritis, epilepsy, psychosis, cancers, or hemoderivatives, if it's a product offered by the Unified Health System, the public system in Brazil, if it's a medicine that is included in partnerships for the productive development, the PDP programs that we have here in Brazil, or if it's related to a fast-track examination requested by the Ministry of Health, those applications will be subject to a patentability analysis. So again, it's important to the ones that are willing to file pharmaceutical applications here in Brazil that depending on the nature of that application, it might be, of course, submitted to Anvisa's prior approval, and it might or not be subject to a patentability analysis by Anvisa. But now that we have these guidelines, the situation is more clear. And of course, if you have any further questions on these guidelines and other features of these guidelines, we will be more than happy to answer. Next, please, André. So now when it comes to limitations to patent rights here in Brazil, according to our patent statute, the right to exclude others does not apply to acts carried out by unauthorized third parties that exclusively produce information, data, and test results to seek market approval in Brazil or abroad after the term of a patent has expired. So this is what we call the Bowler exemption. Another exemption is the one related to the preparation of a medicine according to a medical prescription for individual cases when executed by a qualified professional. So in those cases, the right to exclude others does not apply. So on one hand, in Brazil, we have mechanisms to prevent the unjustified existence of patent rights. We have 2 specific procedures for that. The first one is an administrative one. There is the possibility to file before the Brazilian PTO a nullity administrative procedure after a patent has been granted. There is a specific time for that. And the other possibility is to seek the invalidity of a granted patent in a lawsuit before federal courts. On the other side, we have mechanisms to prevent the excessive exercise of patent rights. So the limitations that I just mentioned are part of those mechanisms, and also compulsory license. Next, André, please. So we opted here to talk about compulsory license because it's a hot topic since last year. And under Brazilian patent statute, there are 5 possibilities for competitors. In case of abuse of economic power, in case of non-exploitation of the subject matter of the patent, in case that the supply does not meet the needs of the market, or in case of non-production, lack of production here in Brazil, and also a situation of dependency of one patent on another. So in those cases, it's possible for a company, for example, to seek a compulsory license. There is a specific administrative procedure to be followed before the Brazilian PTO. But unfortunately, I don't have any example to give because no compulsory license has ever been granted under these provisions yet. I mean, maybe one day, but at least, I mean, those provisions exist and are applicable. We also have two provisions for government use of patents. So the first case is in case of national emergency, and the second one in case of public interest for public non-commercial use. So this license is a temporary one and a non-exclusive one. The procedure, it's a little bit more complicated than a procedure before the Brazilian PTO, because first, the federal executive authorities need to make a declaration that the case is of national emergency, of public interest. And then there is a specific procedure to be followed. So we have in Brazil two emblematic cases related to HIV. In 2001, there was a request for compulsory license for patents covering neofinavir renefavirens, but it did not work out. And in 2007, that's when we had the only case in Brazil of compulsory license of Merck's patents covering Stocrin for efavirenz, and they were both registered at Anvisa for public non-commercial use. So that's the only case we had here in Brazil. And as I said, the compulsory license is temporary, but then during President Dilma Rousseff government, the term of the license was extended for a few years more. Next one, André, please. So now, when it comes to technology transfer in general, and then I will talk more specifically about Brazil, it's well known that stimulating R&D and innovation with and for society involves a greater translation of knowledge from science to business. And our point here is really to say that, or to point out that technology transfer can be improved. The technology transfer process can be improved through IP solutions. The technology transfer process presents many challenges. It's a complex and interactive process with constant redirections of efforts and financial efforts, prioritization of projects related to the transfer of the technology. There are different actors with many interactions. It's the case, for example, of industry-university partnerships. They have different cultural norms. They are involved in different innovation and regulatory environments, and the government policies that apply to those actors are not the same. Contractual forms and arrangements are based on different objectives, values, and motivations of those actors. And the nature of technological research itself is complex and abstract. Knowledge can be tacit and difficult to identify. So what we say here is that using IP and all the technological information that arise from patent documents, if used in a strategic way, it can support decision-making throughout the technology transfer life cycle. So for example, at the beginning of an R&D, and when evaluating a specific project, it's important to search existing patent databases to know if it has been done before, to orient a specific line of project to a result that would be distant from what exists in the state of the art. It's important to know which companies are active in the field. It's really identify the landscape of patents in a technology field. Conduct an upstream due diligence in order to establish IP ownership and permissions on commercialization before licensing patents, of course. When it comes to patent protection, it's really a question of having a clear IP protection and licensing strategy. So the IP portfolio management must be part of the tech transfer strategy. Of course, it's important to manage the patent portfolio and the budget from filing to grant, define what, how, and where to protect. When it comes to marketing, it's again using patent databases to conduct technological prospecting to improve the match between a university solution that has been developed by and university and the needs of a specific company in order to, that's for an industry university partnership, but when seeking to commercialize, sometimes using those databases will help to understand which company would be the best partner to take this technology to the market. And when it comes to licensing, of course, IP is an extremely important part because we will be licensing IP rights, but it's important to have in mind that IP is not necessarily a non-negotiable point during an industry university partnership negotiation. So sometimes some of those partnerships do not happen because of issues related to IP ownership and commercial exploitation, when during the beginning of a partnership, nothing has been developed yet. So of course, IP is extremely important, but actors should avoid unnecessary IP ownership discussion at the beginning of a partnership. And when it comes to commercialization, again, it's also important to conduct freedom to operate analysis, for example, in order to check if the commercialization of a specific product in a specific country does not infringe any third party's rights. So IP can really be used in during different moments of the technology transfer life cycle. And if it used in a strategic way, it certainly contributes to have a more efficient process. Next, André, please. So technology transfer in Brazil, I would like to, before handing over to Professor Rui, I would like to just give a general overview of the framework of innovation in Brazil. We have the a legal landmark of innovation, a law of 2016 that revoked the first law of science, technology, innovation of 2004. So we altered 9 laws and the federal constitution to create a more favorable environment for R&D in universities and companies. There are specific provisions related to IP in this law. One, for example, is that IP rights can be negotiated and transferred from university private partners, which was not something possible before. So everything in this law, and also when it comes to IP, is made in order to was made in order to ease and facilitate industry university partnership. So in addition to that, we have indirect financial support with tax incentive mechanisms, specific laws for that in different areas of knowledge, and also governmental agencies that really help companies and universities to obtain a specific financial support for their projects. So it's really important for industry and universities to interact with those government agencies in order to seek the best financial support, and they also help in the match and finding the best partner. So it's a little bit more than just financial aid, I would say. In addition to that, we have also direct financial support. We have venture capital mechanisms, private equity, angel investments, seed money, corporate venturing, and of course, international funding in Brazil. So I would say that in Brazil, we have a new law that brings more legal certainty to those partnerships. We have infrastructure. There is investment in R&D, which is comparable to the ones in terms to developed countries, for example, Spain and Italy. So there is a law, there is infrastructure, there are financial support, tax incentive mechanisms. So and now we have renewed Brazilian PTO, as we will see further during the presentation. So everything is in place for Brazil to finally make the leap of innovation. So let's see how this will further develop in the future. And now to give you a more concrete example of what happens in university technology transfer, I would like to hand over to Professor Rui from University of State of São Paulo, who will give his experience of technology transfer at the university. Professor Rui, please.
Thank you, Louis. Obrigado, Luiz. Olá a todos. Meu nome é Rui Seabra Ferreira Júnior e eu sou pesquisador e professor associado de uma universidade pública no Brasil, Estadual Paulista. É uma universidade que está espalhada por cerca de 25 cidades no estado de São Paulo. Possui cerca de 50 mil alunos, 120, 130 cursos de mestrado, mais 120, 130 cursos de doutorado. Ou seja, é uma universidade que gera muito conhecimento científico, muita ciência, né? E nós precisamos aprender, na realidade, a gerar tecnologia. Para vocês terem uma ideia, o estado de São Paulo, se fosse um país, seria a 21ª economia do mundo hoje, né, com o seu produto interno bruto maior que países como a Argentina, nossos vizinhos, e também a Bélgica, né, um país europeu. Então, o estado de São Paulo produz a maior parte dos recursos do produto interno bruto brasileiro. Então, gostaria de inicialmente agradecer aos meus colegas aqui presentes pela grande oportunidade de compartilhar com vocês algumas experiências de nosso grupo, né, vivida em uma universidade pública no Brasil. Nosso grupo já teve a imensa alegria de ter suas patentes licenciadas, né, por empresas para tentar desenvolver e levar o produto ao mercado, mas também vivemos a grande dor de ter uma patente mal redigida e se envolver em litígios, em brigas judiciais para assegurar a proteção dessa propriedade intelectual. Então, a minha experiência que eu vou dirigir a vocês é nesse sentido hoje. Nós trabalhamos em todas as etapas do desenvolvimento de um biofármaco, né, desde a sua prospecção, identificação daquelas moléculas candidatas, escolhas dos líderes, os ensaios pré-clínicos e chegando até os ensaios clínicos, agregando assim um maior valor a essa tecnologia. Nesse sentido, nós contamos com uma grande estrutura laboratorial em nossa universidade, né, de pesquisa básica, bem como uma unidade de pesquisa e de pesquisa clínica voltada exclusivamente para ensaios clínicos, né, que faz parte da rede nacional, rede brasileira de pesquisa clínica. Então, nos últimos 10 anos, o nosso grupo investiu em 2 fármacos derivados de bioprodutos que foram compreendidos inicialmente como estratégicos pelo governo brasileiro e assim obteve apoio financeiro do Ministério da Saúde para a sua finalização, bem como a realização de testes pré-clínicos e, por fim, de ensaios clínicos. Nessa trajetória, foi de essencial importância a captação de nosso grupo no que diz respeito à capacitação de nosso grupo, no que diz respeito à proteção de nossa propriedade intelectual, bem como do seu licenciamento. Então, assim, aproveito a oportunidade para mostrar um longo caminho que percorremos, né, que esses 2 grandes projetos multiprofissionais percorreram, desde a sua concepção, dos primeiros estudos básicos, até a proteção de sua propriedade intelectual, bem como da produção dos protótipos e até a realização dos ensaios clínicos. Próximo slide, André, por favor. Bem, o primeiro deles trata-se de um biopolímero de fibrina, né, que já tem mais de 30 anos de desenvolvimento dentro da nossa universidade e é derivado de produtos de origem animal em substituição ao sangue humano que são usados nos biopolímeros de fibrina convencionalmente já no mercado atualmente. Nessa trajetória foram realizados inúmeros estudos acadêmicos, mesmo em pacientes humanos, realizamos estudos acadêmicos, até que em um certo momento as universidades no Brasil como um todo começaram a se estruturar os seus núcleos de informação tecnológica, né, os NITs. Isso foi extremamente importante porque esse núcleo, no caso da Unesp, é a Agência Unesp de Inovação, a UIN, passou a nos ajudar a desenhar uma nova estratégia de proteção dessa propriedade intelectual e, assim, os próximos passos no desenvolvimento dessa tecnologia. Então, uma parte extremamente importante nessa trajetória é o acompanhamento de profissionais especializados em proteção da propriedade intelectual, né, para auxiliar na redação das patentes, contratos de licenciamento, bem como de pesquisa e desenvolvimento, visando a transferência dessa tecnologia a parceiros externos à universidade. Próximo slide, André, por favor. Então, um segundo produto que seguiu basicamente o mesmo caminho que o selante de fibrina foi o soro antiapílico, né? Um único tratamento disponível no mundo para acidentes com abelhas africanizadas, né? Não existe outro antídoto, né, para o tratamento de acidentes com abelhas. Hoje no Brasil isso representa um problema de saúde pública com mais de 22, 23 mil acidentes por ano, em torno de 120 a 150 óbitos, né? Foram cerca de 2 décadas de desenvolvimento que se seguiram no mesmo processo de prospecção e pesquisa básica, extremamente importantes para responder aquelas principais perguntas que vão embasar todo o desenvolvimento do produto, né? Com posterior acompanhamento e assessoria de nosso grupo pela Agência de Inovação para a redação das patentes e assim o seu licenciamento. Esse produto, assim como o anterior, avançou para ensaios clínicos de fase 2 em nossa universidade, né? Conduzido por nosso grupo de pesquisa, agregando assim mais valor a esse contrato de licenciamento e, portanto, retorno à universidade em royalties. Próximo slide, André, por favor. Mas nem tudo são flores, né? Os desafios são enormes e a grande maioria dos projetos ela não consegue ultrapassar o vale da morte existente entre a pesquisa básica e a pesquisa aplicada e o seu desenvolvimento por N motivos, por vários motivos, né? Apesar de que muitos pesquisadores acreditem que esses projetos de pesquisa translacional podem demorar muito tempo, né? Ter a necessidade de grandes investimentos, uma equipe multidisciplinar muito bem treinada e capacitada, né? Nós vemos se fortalecer no Brasil através dos cursos agora de pós-graduação de mestrado e doutorado profissionais, ou seja, que já estão fazendo link com a indústria que vai gerar tecnologia a partir dessa ciência, a partir desse conhecimento. Sabemos que a maioria do conhecimento hoje, conhecimento humano como um todo, não está somente nas bases de dados de artigos científicos, né, de publicações científicas, e sim naquelas bases de dados que contêm patentes e propriedade intelectual. Então, antes de iniciar um projeto de pesquisa, nós orientamos os nossos alunos a também fazer uma busca nessas bases de dados para ver se essa tecnologia já não existe ou se você não vai infringir alguma patente, alguma propriedade intelectual. Então, desta maneira, a gente acredita que o trabalho dos pesquisadores direcionado, né, para a resolução de problemas reais, sejam esses problemas da indústria ou mesmo aqueles que trazem benefício direto ou indireto à sociedade, é a maneira mais adequada de transformar ciência em tecnologia. E, portanto, esta tecnologia deve estar devidamente protegida para ser futuramente explorada comercialmente. E para enfatizarmos aqui, por fim, o fato de que o acompanhamento de profissionais qualificados para o desenho dessas patentes e proteção de sua propriedade intelectual é um investimento extremamente necessário no processo de geração e exploração de uma nova tecnologia. Agradeço novamente e deixo a palavra com o André para continuidade.
Thank you very much, Professor Rui. It's always very interesting to listen to what you tell us. I would like to start with this third part now of our presentation. So the question now is, what are the opportunities? What are the improvements that the new Brazilian IP system has brought? So I will talk half of this part. Half of this part I will talk about this, and the other half it will be with Louis. Firstly, recently there have been some changes regarding both the trademarks and the patents. Actually, trademarks and industrial designs and patents. The main one when we look at the trademarks is obviously the implementation of the Madrid Protocol at the end of the year of 2019. For the ones of you that are not familiar with this, before when you wanted to make a trademark registration in Brazil, you would have to do it directly, and nowadays you can do it alongside other trademark applications in other countries as a central procedural in WIPO, in the World Intellectual Property Organization. So what are the benefits? Nowadays, to register a trademark in Brazil is clearly more time and it's less time, sorry. It's more time effective, and the costs are clearly lower too, due to the fact that you can go to Brazil alongside with other countries or regions. What was the consequence? There is already one consequence because of this implementation of the Madrid Protocol. The trademark registration now has seen a reduction of the examination period to 6 to 12 months. At the same time, the same is happening with industrial designs in terms of reduction. You can see that there is now a period of 3 to 6 months, which is clearly less than what we usually have. When we talk about the patents, I know that most of the people in today's presentation are more focused in patents than in trademarks. We have seen even more structural changes than in the previous part of this slide. There's an increase of priority examination modalities. We are going to talk in more detail about some of them. And I think that this is one of the most important parts of the presentation. There's a backlog attack plan in Brazil for some time now. As you know, Brazil always had a problem with its backlog regarding the patents. Before, all the residents or non-residents in Brazil that filed patents in the country felt for sure that they had to wait for a long time in order to have a decision. So the goal of the BRPTO is to reduce 90% of the backlog in the patent applications by the end of this present year of 2021, which will lead, of course, to a reduction of the examination period. I think that this is probably the main reason why the non-residents and Brazilian residents are starting to make much more patent applications in Brazil than they used to. They see it now as so Brazil had a competitive problem compared to other countries when it came to the time of the decision of the patent. If Brazil doesn't have that anymore, it will clearly surpass most of the countries in terms of interest for all the companies and universities. It's also relevant to say that in terms of protection of the Brazilian patent, we're talking about 20 years from the filing date, but we have to respect the minimum of 10 years from the granting. I told you that there was an increase of priority examination modalities, and here we have 3 examples of these modalities. So the first would be that the applications related to treatment of AIDS, cancer, neglected diseases have that priority. We can all feel there was an impact in the last 10 years. The average time from priority examination to grant is now almost 2 years. It's not much more than 2 years. We already had 37 requests, out of which 86% are suitable, which is clearly an interesting statistics. statistics if you look at it, and 62% of patents granted. Two more modalities would be the Ministry of Health request and concerned substances that I'm not going to pronounce them, not to bore you with these names. So these two, we can look at the last 5 years. And in the last 5 years, we have a period of time, of average time from priority examination to grant of not much more than 1.5 years, 75 requests, of which 79% were decided or shelved, and 23% granted. Before moving with this presentation and moving with Louis, we just wanted to tell you that the coronavirus also had an influence in Brazil and in the Brazilian system. So as you can see, we have this slide dedicated to it. At the end of this presentation, of course, we will send you all these slides. But for now, we can just tell you that there were more than 60 patent applications related to coronavirus that were submitted to fast tracking. They were submitted to fast tracking because there was a request of the Ministry of Health. And as you saw, there was one of the modalities. Among the substances of interest for the Brazilian Unified and Public Health System, the active ingredient tocilizumab occupies the first position. Louis, I think you can proceed with the presentation.
Thank you, Andrea. So in addition to the priority exam modalities that Andrea presented, we have in Brazil, like in many other countries, the Patent Prosecution Highway, the PPH program. So up to date, we have agreements, or at least the agreements in force are mentioned here on the left side of the slide. The phase 1 of the Brazilian PTO's PPH program ended December 2020. The main figures are that I would say that this first phase is pretty much can be considered a success. From 2016 to 2020, the average time until granted decision was reduced on average to 7.3 months. So it's quite impressive for the Brazilian PTO. When we look at specific agreements like the US PTO one, there were more or less 560 applications with 81% granted. When we look at the EPO PPH, 93 applications with 94% granted. The Chinese program with 174 applications with approximately 800% granted. And when we look at the Japanese one, again, a quite significant number with 236 applications and 85% granted. So as I said, this phase 1 can be considered a success. And as a consequence, we now have phase 2 of the Brazilian PPH, of the BRPTO PPH program, which is effective since the beginning of this year. There are some important changes in comparison to the phase 1. So the application period will last until December 2024. The number of applications has increased from 500 to 600 requests per year. There was also an increase from 1 application per month to 1 per week per applicant, and also an increase from 100 to 150 applications per patent classification section per year. And another important change, it concerns patent families. So decisions from any of the partner offices can now be used for requesting PPH, independently of the office where the priority was filed. So this is quite a big change, and it will certainly contribute to the more effective use of this phase 2 PPH program here in Brazil. Andrea, please, the next one. And now when it comes to the patent backlog, just to give you, Andrea talked about it a little bit. So to give you some numbers, that show that it has been also a success until now, and we believe that it will be a success at the end of it. So it started in July 2019. Approximately 150,000 applications were part of this plan. And now, when we look at the statistics in December 2020, the backlog was reduced to approximately 74,000 applications. So more than 51% of applications are already decided or definitely shelved, and over 39% of applications are still under examination. When we look at the numbers related to the backlog of the patents that are submitted to Anvisa's prior approval, the 229C article of our patent statute that I mentioned before, we can see that approximately 10% of the applications are already decided or definitely shelved, and they are pharma related because they go to Anvisa for prior approval. So if the Brazilian PTO keeps this pace until the end of this year, it will certainly attain its objective of reducing by 80% the patent backlog by the end of the year, which is its objective, which is part of the plan. And not only reducing the backlog, but also reducing the time to examine and grant new patent applications. So this is, it's not only a question of resolving this patent backlog, but it's also important to have a sustainable strategy from now on for the new patent applications. So this will certainly contribute to increase the number of patent filings by international companies and universities, and hopefully returning to the level of 35,000 filings per year. Next one, André, please. And here to conclude, I would say that although these changes that André mentioned and the ones that I mentioned right now, we can already see the impact on the productivity of the BRPTO, the preliminary office actions, so the ones related to the patent applications of the backlog plan, they currently account, or at least until the last of the December 2020, account for approximately 80% of office actions from the Brazilian PTO. So it's quite an impressive number. The BRPTO is definitely much more productive than in 2016 and 2018. The number of final decisions, either granting or dismissing an application, are much higher than the number of applications itself. So the BRPTO is more productive, has been implementing significant changes in order to consolidate itself among the main institutes in the world. So, as I said before, everything is in place in Brazil right now for the improvement of the innovation and R&D landscape in Brazil. And if BRPTO continues like this, I'm sure that new opportunities will arise for who will be willing to file patent applications, pharma-related, biotech-related patent applications in Brazil. It will certainly, and it is already, a good venue for patents once again. So thank you very much for your time and attention today. I will hand over to Karina.
Thank you very much, Andrea, Professor Rui, Camila, for the presentations. They were excellent. We have a few more minutes, so I'm going to open the Q&A section. I think we have time for a question or two. So I will address the first question to Camila, but of course, Louis, Professor Rui, if you want to complement Camila's answer, please, you're more than welcome. So Camila, could you comment on how companies and universities can really work together in Brazil, and how difficult or easy these partnerships currently are? I mean, are you aware of any successful partnership among companies and universities?
Claro, Karina. Aqui no Brasil, a gente tem duas vias mais utilizadas com a parceria entre a universidade e as indústrias, né? Uma delas é quando a indústria vai atrás da universidade em busca de um know-how, né? Ela tem um problema dentro da empresa, do desenvolvimento técnico, que ela quer resolver, então ela procura a universidade numa forma de parceria e elas trabalham em conjuntos, gerando uma propriedade industrial, né, uma patente com cotitularidade. Esse é um caminho mais fácil, né? E a gente tem um segundo caminho, que é o caminho de quando a universidade tem uma tecnologia já descrita, né, protegida por um pedido de patente, ou apenas um pedido de patente ainda, e ela vem atrás das empresas oferecendo essa tecnologia. Nessa via, a gente acaba, às vezes, se deparando com um problema de burocracia interno da universidade, que depois o professor Rui pode até comentar um pouquinho a mais, que é referente à necessidade de um edital para que a empresa possa ter exclusividade sobre aquela tecnologia. E muitas vezes as empresas não veem esse edital como uma coisa muito legal, porque você acaba expondo, né, isso é aberto, qual que é o interesse, né, o que a empresa está buscando de trabalho. E outro lado é a demora, né, porque normalmente a universidade tem um pedido de patente ainda só às vezes chegou até o pedido, o PCT, e esse pedido de patente não foi estendido para outros países, né, dentro do prazo. E se você não tem um edital, você não consegue começar a trabalhar em parceria com a universidade para ratear os custos disso, muitas vezes essa tecnologia não é estendida para outros países, né? E como você não tem um edital, você não tem certeza que você vai ser o parceiro naquela tecnologia, as empresas também têm um receio de começar a investir dinheiro nisso. A gente tem, sim, né? A gente teve um caso de sucesso muito grande em parceria com a universidade, que é um produto que hoje é responsável por pagamento de um equivalente mais ou menos a 80%, 90% dos royalties que a USP recebe. Foi uma parceria do caminho da primeira via, a empresa que foi atrás da universidade, atrás do know-how, e a gente trabalhou em parceria com eles. O professor, na época que fez a parceria com a gente, ele não foi muito bem visto dentro da universidade, né? Diziam que ele estava se vendendo até na indústria, e hoje isso mudou, essa visão mudou bastante de lá para cá. E a gente tem outras parcerias também, todas que a gente acabou fazendo hoje, né, que a gente tem, é em cima desse primeiro caminho. A gente vai atrás da universidade, atrás do know-how e trabalha em conjunto com eles. Acho que o professor Rui pode explicar um pouquinho sobre essa parte de edital, que acho que ele deve passar por isso lá dentro também da universidade. Eu passo a palavra para ele.
Obrigado, Camila. Realmente a gente tem esses entraves burocráticos para resolver, né? A questão da inovação no Brasil, ela é recente, né? Porém ela é pujante, né? A gente vê um crescimento rápido e exponencial, que muitas vezes os jurídicos, né? Os corpos jurídicos da universidade e as leis, por ser um patrimônio público, não acompanham. Nós já tivemos, como o André falou, do marco legal de 2016, né, o marco legal da inovação. No entanto, ainda a gente tem muita coisa atrasada por causa que isso não está bem regulamentado dentro das universidades, porque toda essa regulamentação ela precisa ser feita pela Assembleia Legislativa do Estado, né? No caso das universidades públicas estaduais, que aqui em São Paulo, a USP, Unesp e Unicamp. E das federais, na Assembleia Legislativa Federal, né, no Congresso Nacional. Então, essas coisas realmente entravam um pouco essa questão. Porém, eu também sou extremamente otimista e eu vou te mostrar um quadro que me faz ter esse otimismo, né? Ao contrário do que acontece nos outros países, cerca de 70% a 75% dos pesquisadores hoje no Brasil, eles estão trabalhando na área acadêmica, ou seja, eles estão inseridos dentro de universidades, sejam elas públicas ou privadas, enquanto que países desenvolvidos, você tem esses 70% a 80% dos pesquisadores dentro da indústria, dentro das companhias, já fazendo inovação ali. E eu vejo isso como uma grande oportunidade de aproximação com a indústria, porque elas não vão precisar pagar por o salário desses pesquisadores, né, que muitas vezes tem um valor alto para a manutenção de um pesquisador já sênior dentro da indústria. Esses pesquisadores trazem um know-how já fantástico, mão de obra dentro das universidades, né, mestres e doutores, laboratórios já altamente equipados e, inclusive, muitas vezes, financiamento já para os seus projetos. Então, a gente precisa também de um esforço voltando, né, das indústrias para a universidade, como esse exemplo de sucesso que você relatou, para a gente conseguir realmente transpor aquele gap, né, aquele vale da morte e trazer tecnologia e recursos para o país.
Professor
Thank
Rui, eu
you.
concordo plenamente com o senhor. Aqui no Brasil, a maior parte dos pesquisadores estão dentro das universidades. É por isso que a gente vai atrás, entendeu? A gente vai atrás exatamente do know-how. Esse é o interesse. Né? E de fazer parcerias.
Thank you, Camila. Thank you, Professor Rui. Professor, you cited a lot of issues that you face in your day by day, and if we think about the university, mainly almost these issues are because the IP culture in Brazil, in Brazilian universities, could be better established. How do you think this culture could be developed? I mean, how can we demonstrate to the researchers or to the universities that sharing the IP with companies can be mutually beneficial?
Talvez seja hoje, né, como na história humana, seja muito fácil a gente apontar os erros olhando para o passado, né? E muito difícil de você prever esses erros olhando para o futuro. Mas, no entanto, o sistema de geração de tecnologia hoje no Brasil, por nós termos a grande maioria, 70%, 80% dos pesquisadores dentro das universidades, ficou a cargo desses professores na formação de recursos humanos, ou seja, mestres e doutores. Né? Então, muitas dessas pesquisas elas são atribuídas a mestres e doutores nos cursos de pós-graduação aí do país. Esses cursos hoje, esses programas de pós-graduação, eles são geridos pelo Ministério da Educação, né? Através da CAPES, que tem toda uma regulamentação para esses programas. E o produto final desses mestrados e doutorados, muitas vezes é exclusivamente um artigo científico, né, que é o que a CAPES exige. Muitas vezes, o aluno às vezes nem chega a publicar, né, abandona também isso, que é extremamente ruim. Porém, a gente sabe que um processo de geração de propriedade intelectual, ele não se restringe a exclusivamente uma única pesquisa, né? Muitas vezes são necessárias várias pesquisas para você responder várias perguntas e assim, aí sim ter algo que interessa a você proteger, a você patentear. E depois que você publica essas respostas, o patenteamento já não torna-se mais possível. Então, ocorre um choque realmente de interesses, né, no nosso país, que eu devo gerar recursos humanos, mestres e doutores, né? Hoje são quase 100 mil mestres e doutores formados por ano no Brasil, né? Ou eu também devo gerar ciência e tecnologia para o desenvolvimento e como eu protejo isso. Então, esse é um grande desafio que os nossos gestores aí, tanto do Ministério da Educação quanto do Ministério da Ciência e Tecnologia, terão que resolver para o futuro do país. né? Porque a gente vê muitas vezes doutores desempregados, né? Que a indústria nacional acaba não absorvendo. Nós vemos uma evasão de cérebros do país, né? As nossas melhores cabeças indo para universidades em outros países, trabalhar em indústrias de outros países de desenvolvimento, e o Brasil acaba ficando para trás. Então, realmente, esse é um desafio que a gente vai ter que resolver rápido para os próximos anos, se a gente quiser avançar na geração de tecnologia no Brasil.
Thank you, Professor. I think we have time for a last question. I will address it to Louis. Louis, you said that the BRPTO are implementing several changes to become more productive, but do you think these changes are sustainable? I mean, once the backlog is over, do you think the Brazilian PTO will be able to reduce the examination period and the granting period of the patent applications?
So, Karina, thanks for the question. Yes, as I said, I really believe that the BIPTO will be able to sustain its projects, and so there are some reasons for that. I believe that André showed on his slides some changes related to trademarks and other related to patents. But I mean, one thing is to have those changes, which is something very positive and good. But also the BIPTO is really trying to, together with those specific changes for specific areas of IP, it's conducting institutional changes. They are very important. So it's mapping and redesigning its internal processes. It's becoming, in the near future, 100% digital. It has implemented a BRPTO business program to help companies, especially Brazilian companies, of course, to use IP in Brazil in a more effective way. It has an IP showcase where companies can mention their products related to a specific patent pending or granted at the BRPTO. Companies can showcase their products in order to find some partner to commercialize it. There is an IP marketplace set up. This is an agreement with the Danish PTO. There is another specific program related to startups and IP, again, to help startups to use IP and understand the value of IP. There are several technical cooperation agreements and mentoring programs with government agencies to, again, promote and disseminate the culture of generating IP and transfer of technology. And there is also the Brazilian PTO has also an academic institution with a master's degree and a PhD degree. So it's not only a question of implementing those changes to join the Madrid Protocol, for instance, increasing the priority examination modalities and the backlog attack plan. They are, of course, extremely important, but there are institutional changes, important ones, supporting all those changes. And I believe that because of that, due to that, the BIPTO will be able to sustain its project to, for instance, reduce the examination period and granting of patents in the future.
Thank you, Louis. I hope you're right, and I hope we can.
I'm very enthusiastic about our Brazilian PTO now that we finally see a different one, a renewed one. So I am really enthusiastic. And Brazil will certainly become a good venue for patents again, especially in the pharma and biotech sector.
Good to hear. I hope our attendees are as enthusiastic as you are now. And well, I'm afraid we have to finish our section now. Thank you again, Louis, André, Professor Rui, and Camila for the awesome presentations. I would like to answer the audience as well for staying with us so far. And please feel absolutely free to send us an email if you have any additional question, if you want a copy of today's presentation, or if you have a suggestion for a topic you'd like to see in a future webinar, we would appreciate receiving it. I hope you all enjoyed the webinar, and I hope to see you all in our next events. Once again, thank you. Bye-bye. Tchau. Obrigada a todos.
Bye, bye.
Thank you,
Bye.
Amol. Bye-bye.
Thank you. Obrigado.
Bye, bye. Obrigada a todos.